friends, hello and welcome to another episode of The Legal Breakdown. As always, I am your host, Jason Sansone. I am one of the named partners here at Sansone Howell Attorneys at Law. We are conveniently located at 4600 Southeast 29th Street in Del City. We're Suite 500 of the Arvest Bank Tower. Sit on Southeast 29th between Sunny Lane and Sooner Road here over on the south side of Oklahoma City. Friends, we want to thank our host station, KTLV 1220 AM. You can tune in to KTLV 1220 AM on terrestrial radio, or you can listen anywhere in the world with the TuneIn Radio app. You can listen to KTLV 1220 through the TuneIn Radio app anywhere that you've got the ability to stream that station with a data connection. In addition, we simulcast the episode online with both audio and video on the Sansone Howell Facebook page through Facebook Live. We also like to remind our listeners that they can listen or watch former episodes of the show on demand at any time through our YouTube channel or through 3 different podcast sources. Those are on Spotify, Apple's new podcast directory, and Google Play podcast directory. The links for all these, of course, are available on Sansone Howell's webpage, located at SANSONEHOWELL.com, and we provide the links in all of the Facebook Live videos should you wish to access those as well. Friends, today we're going to talk about summer vacation. No, it's not the fun one where you and the kids pack up the car, you go on a road trip, and you're going to see all of the great western states of the United States. You get the opportunity to drive through Colorado, Wyoming, Idaho, Nevada, Utah. It's not that kind of summer vacation we're talking about. I'm joking with the summer part just because it's the season. We're talking about setting aside a judgment, or in legal terms, vacating a judgment. So what does that mean? How would that come about? Why am I telling you about this? It's relatively common for us to meet people and talk in our law practice where all of a sudden they don't realize they're being garnished for some type of debt. So you go to work, you find out the money's being taken out of your check, or you go to check your bank account and money's vanished from your account. And they wonder, how did this even happen? I didn't know about this. I never had notice. What's going on? Well, so that's where the inquiry begins. Let's figure out why. Well, the why is probably because you have a judgment. A judgment is the piece of paper, the legal document that you get when you win a lawsuit, when you win a case. And after you have that, then the law allows you to try to satisfy that judgment different ways that the creditor, the person who won, that you owed money to, is going to attempt to collect on the judgment. The most common is a recurring wage garnishment or levying bank accounts. Those aren't the only ways, but those typically occur. So they're going to take probably up to the maximum in the state of Oklahoma, which is 25% of your gross wages. So you go get your check, you find out it's a lot smaller, they've taken 25%. So that's when we're going to start to explore and figure out what's going on. You look and you find there's a lawsuit somewhere and there is a judgment against you. Now, the reason we're talking today is, if you didn't know about it, how did that occur? Because we're not talking about the situation where you knew, you got served, you filed a response or an answer, you went to trial, you lost. You're not telling me you didn't know about that. You knew, and you knew what the ramifications would be. This is the surprise. So we want to pause here and make sure everyone understands the process of civil litigation. And we've talked about it several times on the program, but let's back up and let's explain how a lawsuit's life goes. What is the timeline? Someone decides they have a cause of action. They've got a reason to sue. They've been wronged. We're talking generally that you owe somebody money or they think you owe them money in some capacity. Okay? So they'll prepare and draft the lawsuit. That's the petition. They'll prepare a summons. And they will go to the county court with the court clerk, and they will record those. They will file them. Now that they're in the record, they have to obtain service against the defendant. And this is going to be one of the core focuses on today's program. But ideally, they get you served, because if they don't, the case never proceeds. But so one way or another, they're going to serve you. After you've been served, it's up to the defendant, who, for our conversations today, is going to be our listening audience or you at home. You've got to do something. It's going to tell you on there how long you have to do something. It's going to usually command you to file some response within 20 days of the date of service. You could file an entry of appearance and reservation of time to buy yourself 20 more days. That has some pros and cons. You could file a motion and ask for all or parts of the case to be dismissed. And of course, you'd have to identify the grounds and legal reasons in support of that motion. Or you file an answer, and that answer is going to identify, in essence, what you agree or disagree with. You're going to admit or deny portions of the complaint, the petition that's been filed against you. And then you move into the case and discovery. But what we're focused on here is when none of that actually happens. When you don't respond timely within 20 days, the creditor can and will take a default judgment, because you had to do something, you didn't do something, you've defaulted, and now they're going to get what they've asked for. So I sue you, I say you owe me $1,000, I have you served by personal process server, I file the notice of service in the case. 20 days goes by, on day 30, I file a default, and I now have my judgment. Now here's what matters. After this, you don't really have to give any more service. You've already done what you needed. You just get to start to collect on the judgment. So now, when I send notice to your employer to start sending me 25% of your check, and you say, I didn't know about it, the question is, did you? Is it an old case from 4 years ago and you just forgot, but you remember you got served and you didn't care, you didn't mess with it? Or did you not get served? One way or the other, what we're talking about is, can we, under any circumstances or what circumstances, have that default judgment, that judgment, unwound, have it set aside, so that we can go back and relitigate the case? Because in the absence of doing that, you get to deal with the results of it. So let's give you the real-world scenario, the frequent scenario. You go to a really crummy, shady, morally dubious auto lender, and you buy a car. And now you owe $20,000, and Blue Book value is 10 at best. It blows up and breaks, and you decide, I don't want this thing anymore because the transmission fell out 3 days after I bought the thing. Hey, they've got every right to enforce the contract, though. It was an as-is purchase. It was a used sale. So you take it back voluntarily, or you stop paying and they forcibly repossess it one way or another. They sell the car, they apply the proceeds to what you owe, and you still owe a whole lot of money. We call that a deficiency judgment because you were upside down on the car. They can collect on the amount of money that you owe, even though you don't have the car anymore, and even though you may not have got much benefit or time out of it. So this is our scenario, is they want to collect on that money for that car you don't have. So they sue you. You, again, have a chance to respond, but you do or you don't. They get a judgment. Years go by, it's built interest because that 20% contract rate. Now you're surprised at, why do you owe $40,000 on a car I don't have from 6 years ago, and I'm being garnished. Okay, so we want to set this judgment aside. So that leads us to the point today. In Oklahoma, our civil procedure rules for civil cases are in Title 12 of the Oklahoma statutes. And the specific area that we care about, that we're going to talk about, is 12 OS 1031. It defines the three main areas that we're going to focus on for having a judgment vacated. There's more. There's a total of 9 reasons, but we're only going to worry about 3. The 3 are defective notice, mistake, or fraud. Okay? So if the creditor, or the plaintiff, obtained a judgment where the defendant had no actual notice of the pendency of the action, or for mistake, neglect, or omission of the clerk, or irregularity in obtaining a judgment in order, or for fraud practiced by the successful party in obtaining a judgment or order. Those are the 3 things we're focusing on. So did they put something wrong and lie, it was fraudulent, the numbers they used in the petition or the way they claimed to serve you, they attached wrong documents. Did the clerk screw up? This thing never should have even been a judgment yet, but they let it get entered. Or the big thing we've been touching on, of course, is this issue of notice. Well, so what are some ways that you can get notice? How can a creditor have you served? Because this comes up very often and you need to know this. We're going to worry about three things: personal service, service by mail, and service by publication. Well, personal service is relatively straightforward. Personal process server comes to the house, hands you something, you've been served. They're going to file a certificate of service with the court saying, I've served somebody. But remember, they don't have to serve you alone, individually. They might, but they don't have to. They can serve anyone over the age of 15 in the household within which you reside at your residence. So sometimes we have some miscommunications. We have issues about, well, my kid got served and they didn't even tell me about it. They threw it away. My brother, my sister, my aunt, my uncle, my cousin, my grandfather, they got served. They forgot. They didn't tell us. That doesn't mean the service wasn't good. That's sort of your internal house problem. But barring that, this happens. Are there issues with personal service? I'll be honest, yeah. There's a couple collection agencies in Oklahoma that have process servers that I really question. Because when you hear a few times from people, I never got served on this, you question the people and you think you might have got served and you forgot. But when you've heard it a couple hundred times, I'm starting to think, yeah, they were sketchy on whether they really served you. Because the other problem is, they claim to have served a residence. What if you don't live there anymore? What if it was a rental property and you moved out 6 months ago? Well, that's not good service. That doesn't mean they're not going to claim they didn't serve you and try to get a judgment. So those are issues. I got to be honest, the hardest, obviously, though, to fight is personal service. From there is service by mail, okay? I mail it to an address, and you either pick it up or you refuse it. Now, number one, service by mail is never the basis for the entry of a default judgment unless the record contains a return receipt showing either acceptance by the defendant or a refusal by the defendant. But even if there is acceptance by the defendant, then what the law very clearly states is any default or judgment by default shall be set aside upon motion of the defendant in a way we're going to discuss in a bit if the defendant demonstrates to the court that the receipt was signed or refused by an unauthorized person, meaning someone who didn't live in your household, they weren't appropriate to sign for you. Maybe it's a corporate situation and they didn't have authority to act as an agent, or maybe they weren't of age in your household to sign. If that's the case, you can file a petition within 1 year after you have actual notice, one way or another, of the default of the judgment, but in no event more than 2 years after the filing of the judgment. These timelines are going to matter. We're going to talk about these some more. But 1 year after you really find out, or 2 years total cap. Okay. Friends, just a reminder, you got questions about this stuff, you're curious, you are always welcome to call in. We've had some issues in the past, I know, I apologize, but I promise I tested it right before the program today. The radio lines are up, they are working. 405-347-7238. You want to know what's going on, you got a situation like this, you've seen it happen, it's happened to you, you want to ask questions, give me a ring, phone lines are working. I promise I tested them. Okay, so we talked about personal service, we talked about service by mail. Let's talk about service by publication. What is service by publication? Service by publication is when the creditor has published through a main media, often like in Oklahoma County, we would use the Journal Record, but in the paper for a set period of time, a notice that a lawsuit has been filed against someone. Now, what's important is you can't use that as your default go-to. You got to already be able to show that I couldn't find you any other way. I wanted to serve you by personal process server. I wanted to serve you by mail. I can't find you, so we need to do publication. So very clearly the law states that before entry of a default judgment, the person who's asking for it and whose only basis for service is publication has to show the court. A court must make an inquiry to determine whether the plaintiff made a distinct and meaningful search of all reasonably available sources to ascertain the whereabouts of the defendant before solely relying on publication. I'm going to be honest, that inquiry doesn't happen all that much. And, good luck arguing with the judge over it. Because the truth is, in a modern world, how do you not find somebody? It's pretty easy to find people with Westlaw, People Search, LexisNexis, Accurate. You got a cell phone, you've got utilities, you got natural gas, you got lights through OG&E, you got a bill with Cox. They're all going to report within a very few months. Public record search, you can find people at addresses. So it's a little bit bogus when they claim they can't find someone at all. Its truth is, I don't think they try that hard, and I don't think the courts scrutinize them like the law says they're supposed to here. But be aware of that. But okay, so someone cannot find you, and then they get a publication default judgment. Now this is a crummy one, because this is when you tell me I didn't know. The truth is, you probably didn't know. Sure, the law says you had service because it was published. But how many of you read the obscure newsletter or the weird newspaper on the back page in 2-point font where it says, a lawsuit's been filed against Joe Bob? Nobody. That's why they use the cheapest paper, the small one, things like the Journal Record. Nobody reads it. You're not going to even know about it. So it's a bit of a lie to claim you really got service, but the law allows it. Okay, well, but that's also why the law allows you to undo these with the greatest level of care. That, at any time within 3 years after the filing of the judgment, you can have the judgment set aside or vacated if it was obtained by publication. You don't, obviously, when we talked about service by mail, well, you got to argue that the person who received service or refused it was not supposed to have. Here, you don't have to do anything. If you got served by publication and you find out later, within 3 years after the judgment, you can come back and say, okay, I just found out about it. Now I'm going to try to argue and have this case. So this is how you start it. This is how we get a judgment vacated and we get it set aside. But some more details. We're not all right. So you say I didn't get service, or I got service within 1 year by mail, or within a year I find out it was by mail and it wasn't to the right person, or it was by publication. We have clients right now where they had motor vehicle repos, they owed a bunch of money, and the creditor obtained default judgments by publication. So technically they could vacate the judgment. They could hire us. We could open that case back up. We could try to roll back the clock. So what's important, though, is, first, 2 timelines. I've been talking about motions to vacate. If it's within 30 days of when the judgment was recorded, or when you got notice, if you were required to be served a notice of the judgment within 30 days of when certificate of service of that was recorded with the court, it's by motion. Much simpler, much easier. If it's outside the 30 days, and you're allowed to do it based on the things we just talked about with the 1 year, 2 year, 3 year timelines, then it has to be in a different form. It's by petition. So if more than 30 days after a judgment, decree, or appealable order has been filed, proceedings to vacate or modify the judgment shall be by petition, verified by affidavit, setting forth the judgment, the grounds to vacate, and the defense. And the defense, if the party appealing was the defendant. Okay. Why did I stress that? Why did we go into that so much? Because here's the thing. We've said it, and we've talked about it, but I want to be very clear. When you vacate a judgment, that specific pleading, that act, that end result, the finality of the lawsuit is set aside. It doesn't mean you win. It doesn't mean it's game over. Congrats. It just rolls back the clock. It takes you back from the finish line to the starting line. Right? The starting line in the lawsuit was the plaintiff went down, they filed the lawsuit, they filed a summons, and then they tried to have it served on you. The finish line was the judgment. You didn't win now. You don't get a judgment in your favor. That's not what we're asking for. You're asking to vacate the judgment. That takes you back to the starting line, to the beginning of the case. And so, that's bringing us now full circle to this conversation of what makes sense, what you should do, how this works. Because if you're within 30 days of when the judgment was recorded, and you want to allege fraud, mistake, maybe bad notice, you don't even have to come up with a reason why Your defense in the case, you'll bring that when you actually file your answer or a motion. But if it's over a year, the law requires that as part of this petition to vacate, you've got to articulate your defense. And so, what is that going to be? Because if the whole thing is, I didn't know about this, yeah, it's true. It's crummy that maybe they did it illegal and they obtained a judgment against you with improper service or in the bad methods. But the reason they keep getting away with it and the reason it happens is because even if they do it right, if the end result is the same, well, what are we going to change? So if you bought a car and you've got no defense to that contract, and you were to admit on the stand or in a deposition, I bought it, I gave it back, I signed a contract, I owe the money, I don't contest that they follow the state law procedures to sell and auction the car off, we're still going to lose the lawsuit. We're going to be in the exact same position. So 5 years ago, they took a default judgment. Now, we get it vacated for some reason. We roll the clock back. They still get the 5 years worth of interest dating back to the date of the default. What changed? You spent a whole lot of money for no reason on time and attorney's fees, and maybe we weren't even successful because the judge wants a valid defense before they're going to open this thing back up again. So that's one thing I really wanted to spend a little time on this episode, that it's an unfortunate truth. We have to have this conversation with people all the time, but if you owe the debt legitimately and you don't have a great defense to the debt, then you need to contemplate a different way to resolve this, whether that's settling it, whether that's trying to get a payment plan, whether possibly that's bankruptcy, as we've touched on in depth in many other episodes. And of course, whether bankruptcy does or doesn't make sense or what your options are all depend on your circumstances. If this is one debt of many, if you've got 4 judgments, don't spend $3,000 on an attorney to have the judgment set aside. Just discharge all of them. File a bankruptcy. If this is the only debt you have, and you didn't even know you had it, and it's bogus, then it makes much more sense to obviously protect yourself, protect your credit, and fight this case. But let's go into now some of the policy implications on whether or not the court should or will let you do these things, whether or not they're going to favor vacating a default judgment. Because we've talked about this is what's supposed to happen. We talked about the black letter law of the statutes. We talked about Title 12, 1031, and all the other components to service and process by personal service, by mail, and by publication. And, the fact that if it's by publication, you got 3 years to unwind the thing if you got a defense to it. Well, the answer is they're very likely going to grant the petition or the motion to vacate. The Oklahoma Supreme Court, in a 2000 case of Ferguson Enterprises v. Webb Enterprises, stated that default judgments are not favored. Vacating of a default judgment is different than vacation of a judgment when the parties had the opportunity to be heard on the merits. And that's what we've been talking about today, is defaults, where you never even had a chance to appear. And judicial discretion to vacate a default judgment should always be exercised so as to promote the ends of justice. That, hey, I didn't get my day in court, I should get my day in court. Because it's totally different if you just lost and you're going to cry about it and have sour grapes about losing and want to set aside a judgment where you litigated. This is where you never had your day in court. And then lastly, out of the 4 points, they said a much stronger showing of abuse of discretion must be made where a judgment has been set aside than where it has not. In other words, to appeal a order is that if you don't set aside a judgment, it's pretty easy to show that there was abuse of discretion on the part of the judge. If you can appeal that order, you're likely to prevail at an appellate court level. If they do set aside the judgment, the other side that's upset about it and doesn't want it set aside for default is going to have a much higher burden to complain that, hey, why do I have to litigate this case? Because we don't just use rules and technicalities and little ticky-tack things to crush people, especially non-sophisticated parties without attorneys, that the law is going to err to promote the ends of justice. In deciding whether to grant a motion to vacate default judgment, trial courts should consider whether vacation could be granted without substantial delay or injustice, and whether allowing the default to stand would work a serious injustice. That was SL versus Tulsa Turbine Engines and Aircraft, a 2013 Oklahoma Court of Civil Appeals case, but it was citing a 2005 case, St. John Medical Center v. Brown. So we've just talked about a total of 3 cases now, 2 from the Court of Civil Appeals and 1 from the Supreme Court. All of them say, yeah, come on, court, don't let people just beat each other up with the rules. We want to err to the side of letting people have their day in court and the side of justice. So what have we covered? Let's sum it all back up. Let's talk about our big episode of summer vacation. You're out on summer vacation today, and look, you're learning about vacation. Well, let's rehash. A lawsuit starts with a petition and a summons. It has to be served on someone in the way the law allows. After that's done, there's a time period to respond. If you fail to respond, the plaintiff, who we're calling also the creditor, could take a default judgment. They can get what they've asked for without you having any more say in the matter because you didn't exercise your due process rights. You didn't do anything to defend yourself as you were told you had to do within the time period to respond. They do that, they have a judgment. Now they have the right to try to collect on that judgment. In Oklahoma, they could levy your bank accounts, they could ask for hearings on assets, they could garnish your recurring wages up to 25% of your gross. You find out about it and you go, wow, I didn't even know anything about this. I'm having my check taken. Your first inquiry is going to be, did you really not know? Look up the case. You're going to find out, where is this? What is this? How did they obtain service? Because again, we hear all the time, but sometimes, it goes both ways. There are plenty of people where I know you got served and you didn't realize it or you chose to ignore it. You took an important legal document and you threw it in the trash. There's other people where I have a pretty good feeling they're telling me the truth. They never got served. So the 3 main areas in which we could get the judgment vacated: for lack of notice, like we've been touching on, for mistake, or for fraud. We've spent the most time talking about notice. So you're going to look at the type of service that supposedly was obtained against you, whether that was personal service, service by mail, or service by publication. If it's personal service, you're going to have the biggest uphill battle because typically there's going to be some server who's going to testify, yeah, I served you or I served you at that residence. But if you can show you didn't live in that residence at all, you might be successful. You haven't been there at the time you were supposedly served, you might be successful. If it's service by mail, same thing. You can say that I was never there, or that the people that refused the mail or signed for the mail were not authorized to accept and sign for that they were not my friends, family, relatives, dependents. They were under the age of 15, those details. Or if it's service by publication, period. Within 3 years of the original judgment, you don't have to have a reason of how they got the service. You could just say you want to set the judgment aside because, as we already said, service by publication is a little flaky. It just means that we put something out there and we hope maybe somebody told you about it or that you heard about it. Those time limits on mail, you've got to try to file the motion or the petition within 1 year of when you obtain notice, or no matter what, within 2 years. So even if you get notice 3 years later, unfortunately, time barred, can't do it. With the publication, 3 years, hard cap period. So the judgment was obtained 5 years ago. Too late, still have to try. You should have done it within 3 years somehow. Now, can you do it out of time? Can you make the arguments? Maybe you can, maybe you can't, but not according to the black letter of the law. Black letter of the law says we're in trouble at that point. Now, parting note, we're almost out of time. Want to focus, stress, and remind everybody. Think, though, do you have a good defense? Because it doesn't do any good to roll back the clock to the starting line if we're going to end up in the same place on the finish line, still losing. So, friends, hopefully this has been very informative. This is a big issue. We see it all the time with default judgments and whether or not you can set it aside or you can vacate it. Have a wonderful and safe week. Enjoy your summer. Stay cool. This is Jason Sansone with The Legal Breakdown. The Legal Breakdown. The Legal Breakdown. The Legal Breakdown.